If you don't name a guardian for your minor children and both you and your spouse pass away, someone needs to go to court to be named the legal guardian for your children. If you haven't named somebody, that means that maybe multiple people will try to become the guardian, friends, family members, and there may be a fight. If you name a legal guardian, it is less likely that there's going to be a fight about who should take care of your kids. If something happens to you and your spouse and your children are left alone, you want to make sure that you have designated someone to raise them, to care for them, and to provide for their needs until they are old enough to care for themselves. In addition, you want to make sure that that guardian has the financial resources to be able to take care of your children. So in your will, you can provide for something called a contingent trust that says, if I pass away when my children are still under the age of 18 or some other age that you designate, that money remains in trust and is handled by someone else. That may be the guardian, it may be somebody else you name, so that you have sort of a division of authority on who's managing the money versus who is raising the kids. You can make that trust last as long as you want. Sometimes our kids are not really financially smart enough to be handling money at the age of 18, so you may not want to give them authority to handle all that money at 18, and you can leave it in trust until they're old enough to handle it themselves. A testamentary trust is one that is created by your will when you die. Many trusts are created before you pass away. They may be revocable or irrevocable, but you put your assets in trust ahead of time. The testamentary trust is created when you die. The best way to prevent family disputes over your children's care if you and your spouse pass away is to name who you want to be the guardian of your children and who you want to be in charge of the finances that will be used to care for your children. Not naming guardians, not naming trustees is the best way for people to create an environment where your family is going to fight over these matters. In addition, you want to make sure that you name who you don't want to be your kids' guardians. The problem is that if you don't name anybody, people can fight over that. And a court will make the final decision who should be the guardian. They're going to honor your wishes to the extent possible. And if there's someone you wouldn't want to raise your children, make sure you've designated that as well. Protecting your minor children is an important aspect of any good estate plan. Please give us a call at DeFord Law Firm and we can walk you through making the best decisions that you can for your family.